Welcome. It's really great to see everyone here. This is the panel on religion and speech. I'm Melissa Murray. I am a professor at NYU, and I'm really delighted to moderate this conversation today. We have a fantastic group of presenters, so I will introduce them alphabetically, and then we will go to presentations. So I'm very delighted to meet for the first time on Zoom Stephanie Barclay, who is an associate professor of law and the director of the Religious Liberty Initiative at Notre Dame University's Law School. I'm also glad to be here with Luke Boso, who's an assistant professor at the University of San Francisco and a visiting professor at UC Hastings College of the Law. Justin Collins is an associate dean for research and academic affairs and a professor of law at Brigham Young University's J. Reuben Clark Law School. And Marc DeGirolami is the Carey Fields Professor of Law and co-director of the Center for Law and Religion at St. John's University. And finally, Shaakirrah Sanders is a professor of law at the University of Idaho, and she will be a visiting professor at Brooklyn Law School next year. So we are going to take the presentations in alphabetical order. So first, or the order that they're presented in the program, which means that Luke, despite not quite being alphabetically first, you will go first. And then we'll be followed by Justin and Stephanie, and then Marc, and then Shaakirrah. And each presenter has 12 minutes. I'll keep the time and give you a warning in the chat, so keep your chat up and look for that. And we'll just go through all of the papers, and then I will provide a little bit of commentary, and we'll open it up to Q&A from the audience as well. So Luke, if you're ready, I can start the timer.
Sure thing.
Okay.
All right, well, thank you, Melissa, and hello, everyone else. It's an honor to be here. I'm excited to share this project. This is a work in progress. This is my first time presenting. The title of the paper is called Anti-LGBT Free Speech and Group Subordination, and it's forthcoming this summer in the Arizona Law Review. The focus of this paper is on the tension between liberty and equality, and specifically the tension between civil rights laws that prohibit discrimination on the basis of sexual orientation and gender identity, and First Amendment claims seeking exemptions or carve-outs to those laws. Free speech has long been a rallying cry for those who favor limited government and an effective legal tool for achieving the same. And today, conservative and religious objectors to LGBT equality are increasingly relying on free speech principles to blunt some of the legal advances we've seen in recent years. At the crux of these claims is the argument that compliance with LGBT inclusive anti-discrimination laws unconstitutionally compels speech or censors disfavored religious views, for example. But from an equality perspective, sanctioning free speech as a de facto defense for noncompliance poses serious concerns about the scope of anti-discrimination law with respect to employment, housing, public accommodations, etc. So this article challenges some conventional thought about free speech, and in that way, I recognize that its proposal and its theory is somewhat controversial. The article argues for a First Amendment jurisprudence that embodies anti-subordination principles. And in making this argument, it critiques the Supreme Court's First Amendment jurisprudence that currently tends to be a bit more libertarian in nature, an approach that largely leaves speech unregulated and tends to elevate individual liberty interests over equality interests. So the remainder of my talk today will proceed in two parts. So first, I'll describe the court's current libertarian stance towards free speech, and I'll explain how the court has helped lay the groundwork for these First Amendment claims to be exempt from civil rights laws or be accommodated by them by tucking concerns for religious and conservative objectors into the very decisions that ushered in LGBT equality. And then second, I will talk about what an anti-subordination theory for mitigating this tension means and how it might actually play out when resolving competing claims to free speech and LGBT equality. And simply put, to cut to the chase, if promoting one party's free speech interest over another party's equality claim would perpetuate perceptions of inferiority about a historically oppressed group, then this article argues that the free speech claim should fail, kind of regardless of the form that the free speech claim takes. So let's take a few moments to start by examining the court's current, more libertarian-oriented approach to the First Amendment in the context of LGBT rights. So even in the court's most celebrated pro-LGBT decisions like Romer, Windsor, and Obergefell, the tension between equality and liberty has been omnipresent. In majority, concurring, and dissenting opinions alike, members of the court have sometimes gone out of their way to express concern for religious and conservative objectors who might be negatively affected by a pro-LGBT outcome. So for example, in Obergefell, which struck down all remaining same-sex marriage bans in the United States, the court suggested that those who object to LGBT equality may continue to, quote, teach their beliefs, but it didn't elaborate on whether teaching those beliefs included engaging in conduct that contradicts anti-discrimination law. And in his Obergefell dissent, Justice Roberts makes a similar point and expresses his discomfort. He says, quote, "The First Amendment guarantees the freedom to exercise religion, among other things. Ominously, that is not a word the majority uses." Roberts concludes by essentially casting opponents of LGBT equality as the true victims, seemingly taking offense that the majority, quote, "feels compelled to sully those on the other side of the debate and paint them as, quote, bigoted." And then as another example, just last summer in Bostock versus Clayton County, Georgia, the court held that a federal law prohibiting sex discrimination in the workplace encompasses discrimination on the basis of sexual orientation and gender identity as well. But the majority cabined its decision by gesturing at the very end towards future cases rooted in First Amendment objections, suggesting that in some circumstances, exemptions to LGBT inclusive anti-discrimination laws might be warranted. I think that one explanation for why the Supreme Court has gradually grown receptive to the idea that the First Amendment could be a possible tool to kind of blunt some of the effects of LGBT equality is that the court's current approach to the First Amendment has become more libertarian in recent decades. So a libertarian view of the First Amendment, in short, represents a negative check on the government's ability to interfere with private ideas. So limiting and often outright prohibiting the regulation of speakers, subject matter, and viewpoints. And this approach is perhaps best illustrated by content and speaker neutrality rules, which refer to the general principle that the state cannot regulate speech based on what message the speaker wishes to convey, kind of no matter how offensive that message might be, or who the speaker is, no matter how much power that speaker might have to distort the marketplace of ideas with money or perhaps with the bully pulpit. And the command of speech neutrality kind of was initially a minority-friendly approach because in historic practice, the government sought to silence and punish minority views and speakers more often than not, which had the effect of perpetuating subordination of certain marginalized groups. Today, speech neutrality rules often benefit majoritarian interests that are invested in preserving the status quo and minimizing the government's ability to promote equality. And in many ways, part of what this article argues is that the court's current approach to free speech mirrors its current approach to equal protection in quite a few ways. So under equal protection today, rather than focusing on the disparate impact that governmental actions have for certain minority groups or engaging in a robust search for discriminatory intent, the court today favors formal equality, often defers to governmental explanations for disparate impacts, and treats all invocations of race, for example, as inherently suspect, regardless of whether the government acted to help or harm the racial minority group in question. And judicial commitment to this ideology of formal equal treatment, kind of both in free speech and in equal protection doctrine, often leaves little room for governmental oversight that attempts to achieve equitable economic and social outcomes. So what would an anti-subordination approach to free speech look like? This brings me to the second part of the talk today. In short, an anti-subordination approach or theory of free speech would recognize and respond to inequitable results of certain speech, like the reality that hurtful speech directed at members of minority groups impose barriers and psychological harms not experienced by members of majority groups. And this isn't necessarily a new theory. So for example, critical race theorists and other progressives in the 1980s challenged the prevailing libertarian view of the free speech clause as insufficiently responsive to the problem of hate speech on college campuses, for example, essentially arguing that hate speech should be an unprotected category. In the context of competing claims to free speech and equality that we see today, interpreting the First Amendment through an anti-subordination approach would take things like history and context and political power into consideration. it should matter whether a successful compelled speech claim, for example, or allegation of governmental censorship would impose barriers to full participation in civic life for a group that's has been historically excluded. And the Supreme Court itself has invoked both implicitly and explicitly this idea of anti-subordination in striking down governmental actions, at least under the Equal Protection Clause. And so I argue that these cases are instructive here as well. Two of the best examples here of anti-subordination theory at work appear in Brown versus Board, and then in Obergefell versus Hodges. So in Brown, as we all know, the court struck down race-based segregation in public K through 12 schools. And famously, the court kind of morally and legally anchored its equal protection analysis to the psychological effects of separate schools for Black school children. The court said, quote, "To separate them from others of similar age and qualifications solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone." And the court's focus on this kind of perceived status-based inferiority led to a widespread understanding at the time that race classifications that have either the purpose or effect of enforcing racial hierarchy was the principal equal protection harm in Brown. We see this in Obergefell as well, a much more contemporary example where the court more explicitly relies on anti-subordination principles. The court explained that these bans have the effect of teaching that gays and lesbians are unequal in important respects, and that these laws are thus demeaning. And the court went on to unambiguously state that they serve to, quote, "disrespect and subordinate gays and lesbians as a group." So this attention to status hierarchies, I think, can inform free speech in a way that leads to more equitable outcomes. A case out of the Ninth Circuit called Harper versus Poway, I think, offers a concrete example of the anti-subordination theory at work in mitigating this tension between liberty and equality. The legal dispute in Harper springs from a contentious history of student conflict over LGBT rights at a public school in California. So in 2004, one student named Harper wore a t-shirt with the following message: "Be ashamed, our school embraced what God has condemned," on the front, and then "homosexuality is shameful" on the back. He was asked to take off his shirt. He refused. He was punished for the day. He ended up bringing a free speech claim in federal court, suing the school. And in evaluating the free speech lawsuit, the Ninth Circuit explained that students have a right to be free from, quote, "psychological injury inflicted by others," and specifically, quote, "students who may be injured by verbal assaults on the basis of core identifying characteristics such as race, religion, or sexual orientation have a right to be free from such attacks while on school campuses." The Harper court then explained that not all verbal attacks are alike. Some have particularly devastating effects for vulnerable groups. And so, citing interdisciplinary scholarship and empirical evidence, the court explained, quote, "Speech that attacks high school students who are members of minority groups that have historically been oppressed, subject to verbal and physical abuse, and made to feel inferior, serves to injure and intimidate them, as well as to damage their sense of security and interfere with the opportunity to learn." So in rejecting the free speech claim, the Ninth Circuit effectively applied this language of anti-subordination, understanding that hurtful and exclusionary speech targeted at minority group members can both intangibly enforce status hierarchies by perpetuating these feelings of inferiority, and tangibly enforce status hierarchies by interfering with minority students' educational opportunities. And we're seeing a lot of these conflicts today kind of reemerge and take new dimensions. There are several cases where claimants raise free speech as a justification for refusing to provide certain services or employ, and some where folks are arguing that they shouldn't have to use a person's proper name or chosen pronoun. And I think that the anti-subordination principle can help kind of achieve more equitable results in these contexts. And I see that I'm out of time, so I will go ahead and stop for here.
Thanks, Luke, and thank you for observing the time restraint. So Justin and Stephanie, your turn. And so I will chat to you in the private chat function to let you know when you have a couple of minutes left and then when you're at time, okay?
Wonderful, thank you. It's an honor to be here. Stephanie's asked that I kind of give an overview of our paper, and then she'll add some things in the remaining time. So our paper is a comparative piece that looks at strict scrutiny and proportionality analysis in the context of religious exercise claims. And it was prompted by a number of things. In recent years, there's been increasing attention among American constitutional scholars to the global model of proportionality analysis. Um, the this recent spate of religious exercise claims arising from the COVID pandemic has brought some of these questions to the fore, and the Supreme Court seems poised at least to consider revisiting the received approach from the Smith versus Employment Division versus Smith. We examined some of the most important proportionality jurisdictions and looked at religious accommodations claims across a number of these, as well as within the United States. Let me begin by saying just a couple of things about proportionality analysis itself. I imagine it's going to be familiar to many, but perhaps not everybody. So like strict scrutiny, proportionality analysis requires that any restriction of a fundamental right be justified. And the analysis is divided into 4 steps or 3, depending on how you count. The initial steps don't do an awful lot of work. The first step requires that the government objective be lawful, be legitimate. And the second, that there be a rational connection between the government's chosen measure and its stated end. And those 2 steps catch a number of runaway cases, but most of the work in proportionality analysis is done by the 3rd and 4th steps, which are known as the necessity prong and the proportionality as such prong, or proportionality in the narrow sense. The necessity prong is functionally very similar to the narrow tailoring requirement under strict scrutiny. It requires that the restriction on the relevant right be no greater than is necessary to secure the government objective. And the 4th step require that even if the restriction is necessary, that it not be disproportionate. And this is the test that gives proportionality its name and much of its controversy. So we looked at a number of religious accommodation cases arising in proportionality jurisdictions and in the United States. And what we found is that both across jurisdictions and within jurisdictions, the chosen framework wasn't really driving the outcomes. The big difference was not the choice of proportionality versus strict scrutiny or some kind of tiered analysis, but the big differences came in the application. And we noted across a range of cases and jurisdictions that there were really 3 determinative factors. 2 of them related to the necessity or the narrow tailoring prong, and 1 of them related to the proportionality in the narrow sense prong. Those 3 factors are whether the court required the government to treat religious claimants in an even-handed way with respect to analogous secular conduct. Right? So the first factor is the relevance or the non-relevance for the court of treatment of analogous secular conduct. The second factor was with respect to the necessity prong was whether the court placed the burden of proof on the government. Or deferred to the government's assessment or evaluation of necessity. And then the third, which relates to the evaluation of proportionality in the narrow sense or balancing, was whether the court yielded to the temptation to redefine the theological stakes in a way that minimized the conflict. So I want to give 2 examples of each of these factors and then hand things over to Stephanie. So in terms of the relevance of analogous secular conduct, An example of a case that that treated it as highly relevant is the Multani case from Canada about 15 years ago. In Multani, a Sikh student wanted to bring a kirpan to school. And the school had a ban on any kind of weapons, and so he wasn't allowed to bring it, even if it was sewn inside or kept inside his clothing. And in ruling that this was a disproportionate limitation, the Canadian Supreme Court pointed out that there are all kinds of sharp objects at schools, or dangerous objects. There were scissors, there were baseball bats, there were forks and knives in the cafeteria, and that it couldn't truly be necessary to prevent bringing a small ceremonial dagger sewn inside the clothing. So in that case, the different treatment of analogous secular conduct was driving the outcome. By contrast, the European Court of Human Rights a few years back considered France's burqa ban, which forbade face coverings in public places, and the complainant pointed out that the law allowed all kinds of various face coverings. If you were a construction worker, if you were engaged in a number of different activities, even for certain religious festivals, you were allowed, traditional religious festivals, you're allowed to wear a face covering, but you weren't allowed to wear a burqa. And the court viewed that as not relevant, that the analogous secular conduct was subject to different rights considerations and not relevant for this analysis. So even though both courts are nominally applying the same kind of proportionality test, they reach very different outcomes based on the relevance as they see it of analogous secular conduct. The second factor is the imposition or not of a burden of proof on the government with respect to the necessity prong or the intensity with which the court the intensity of that burden. So by way of contrast with the European Court of Human Rights decision with respect to a burqa ban, Germany's Constitutional Court has decided a number of headscarf restriction cases over the years. One of them in 2015 had to do with public school teachers. There was a Muslim woman who wanted to teach in a headscarf. And the state government's claim was that this would disturb the peace of the school, what they in German called the Schulfrieden. And the court said that might happen, but you've not given any evidence that this has happened, that this is making for unharmonious relationships within the school. If you allow this and over time there are problems, then maybe you could revisit this. By contrast, you see in some of the COVID cases a great willingness to defer to government assessments of risk. That has changed a bit over time, and that's probably appropriate. That early on, when there's less knowledge, you'd be more deferential to restrictive measures, and there's been some moving back from that. I'm going to move quickly through the last one so Stephanie can weigh in. In terms of redefining the theological stakes at the balancing phase, this happens. This is an issue in the United States as well, even though there's not nominally a balancing phase in the strict scrutiny test. But for instance, the U.S. Supreme Court struck down a measure that forbade a Muslim prisoner to grow a short beard. And one of the defenses of this restriction was, well, he's still allowed to pray several times a day. And the Supreme Court said that's not of relevance. We can't. You can't say that you're allowing somebody to engage in different religious conduct, and that should be virtually the equivalent. By contrast, in a Canadian case late last year, the government had banned local government had banned all religious gatherings, including a drive-in service. And in upholding this, one court said, well, you can still watch the same service on TV, And so that's the same religious experience, whether you're gathering in person or viewing it on YouTube. But it might not be for the religious time. I'll stop there and let Stephanie weigh in for the last couple of minutes.
Thanks, Justin. And thank you all for having us here. It's great to be with you. Just a couple of the things that I'll note is that even though these factors Justin highlighted, we think are something that are common, regardless of the label that you're using for constitutional adjudication, whether that's proportionality or strict scrutiny, that doesn't mean that we don't think that strict scrutiny and proportionality might still have things to learn from each other. So, for example, under strict scrutiny, we thought that, at least in our view, one of the things that seems beneficial if we're looking for ways to avoid unnecessary conflicts and still optimize religious liberty was to make sure that sometimes in certain cases, even if the government is doing something that it says is necessary, it still may not be justified. And one example we pointed to is in Ling, the government said it was necessary to build a road through this sacred site of Native American, a number of different tribes, even though the evidence was undisputed that it would really essentially destroy their ability to continue their way of life and their cultural practices there. And that's an example of a spot where maybe if the government had been engaging in a little bit more of that proportionality analysis on the back end as sort of the last safety valve sort of question, the court may have decided that building a road that actually never ended up being completed, it was a road to nowhere ultimately, wasn't worth the harm that it caused for these different tribes. We also point out that in all of these proportionality jurisdictions across the world, there isn't really a debate about whether we should have exemptions or not. It's just not a big deal. The bigger question is the government justified or not? And that might be something that we can learn from here and spend less time sometimes having concern about the very existence of religious exemptions under our regime. I'll go ahead and stop there, and thank you again.
Okay, thank you, Justin and Stephanie. All right, Mark, 12 minutes, and I'll let you know in the chat when you're approaching time.
Great. Thank you very much, and to the organizers, and especially to Professor Murray for commenting on this, what is still a quite drafty paper. So the paper examines the question of the political priority of the religion clauses, and that requires me to spell out a few terms first. So by political, I mean what constitutes the regime, the sort of foundational settlements that bind the polity as a people, that represent what the political theorist Pierre Manent has called the common thing. Second, priority, and I identify three kinds of priority. Conceptual priority, whether an idea is derived from or logically dependent on another. Second, historical priority, actual temporal firstness in time. And then third, priority of political importance. How much do we care about it politically? Third term, establishment. Following the Supreme Court, I take establishment to mean the settlements of church-state relations. And establishment in this sense includes civil religion, another term I have to define, the super political values or commitments that transcend the polity, but that are bound up with it. And finally, fourth, free exercise. This will be more familiar. I focus on religious exemption from neutral and generally applicable law. So if we put this all together, the core claim of the paper is that establishment has, in the United States, a strong claim of political priority in all three senses to free exercise as religious accommodation. The first part of the paper examines the question of political priority in the abstract. And what it says is, the basic choice of establishment, of a settlement on the question of church and state is politically foundational. Every polity reaches such a settlement, including those that separate church from state. Every polity makes a foundational choice about its civil religion, about the super political commitments that bind the polity and transcend the regime and reflect the regime. That settlement can be shifting and dynamic and can be uncertain and complex. It can be difficult to identify, but the settlement is foundational. For example, some claim that the American civil religion settlement could be described as a mixture of providentialist and secularist conceptions. Others emphasize the secularist conception alone as foundational, and so on. Rights of exemption are, I argue, politically secondary to these civil religion regime settlements. They are decisions to apply the regime settlement selectively and partially. They weaken the authority of the settlements inasmuch as they are micro-negations of the settlements. And so in this way, they are regime destabilizing rather than settling. So first come the settlements, then come the exceptions. Now, many people might dispute this. They might say, no, 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 exemptions in America are the political regime's foundation. That's the whole innovation of liberal democracies like the United States. The polity's aims are always penultimate. The individual's aims are always ultimate. In the paper, I argue that whatever may be true of the natural right of free exercise itself, exemptions are different. And now there's a debate about whether rights of exemption were part of the natural right of religious freedom. Several scholars say no. Others, including Professor Barclay, I think, say yes, or at least maybe I'm putting myself in this camp, say maybe. Still others say that rights of exemptions were correlative to the civil religion establishment of a jurisdictional church-state separation. Even if all that's true, I still think that it still means that accommodation requires some antecedent church-state regime settlement. Whatever basis that has, whether it's metaphysical or liberal and so on, that settlement comes first conceptually, and then the polity decides about exceptions. So the second and third parts of the paper test the thesis of political priority as a matter of Supreme Court religion clause doctrine. This is a kind of an inductive rather than a conceptual method in the latter half of the paper. And what I mean here is not that the Supreme Court intentionally elevated a clause or subordinated another one. It's that one can understand the effects of what the court did in terms of these questions of political priority. And in the 20th century, the court's framework could be called civil religion dismantling. The dismantling was of the American Christian civil religion that obtained in 20th century America, and which consisted of a broad set of practices and institutions and customs that were foundational church-state regime settlements. And by the metrics of historical priority and general political significance priority, the court's disestablishment cases were politically prior to the court's accommodation doctrine. So when Everson was decided, and for actually a while thereafter, there was no required accommodation. The rule was the same one from Reynolds versus United States, and accommodation was kind of off stage. What was center stage were the court's disestablishment cases: financial support of parochial schools, state-sponsored religious displays, religious affirmation requirements for public office, regulatory and licensing laws, supporting religion, Bible reading, prayer, moments of silence in public schools and school events, legislative prayer, public school curricular decisions reflecting traditional practices, religious practices and views. All of these were sort of the heartland of the Supreme Court's church-state doctrine, and their effect was to dismantle the existing civil religion regime. I don't claim that the court was acting alone. There were, of course, many other cultural forces at work. Nevertheless, the doctrine, and in particular the rule that the government could only act for secular reasons, really did transform the civil religion regime. Right? The court spoke about secularism and religion without really defining these terms, but when it policed religion, it was dismantling the political Christianity that defined the civil religion of the regime. When exemption arrived later, temporally, it occupied a secondary political status inasmuch as disestablishment doctrine set the terms for exemption's operation. How did this happen? Well, far from, as some scholars claim, offering the existing civil religion regime a kind of compensating gift for its disestablishment decisions, the court's accommodation decisions were disestablishment reinforcing. They were civil religion regime destabilizing. So this sort of confirms the kind of conceptual discussion early on. Sherbert constitutionalized mandatory accommodation for a Seventh-day Adventist claimant from a state rule establishing Sunday as a uniform day of rest. That had been an important civil religion regime settlement, one that only a few years earlier was upheld against constitutional challenge in Braunfeld and McGowan, although for somewhat peculiar reasons. Both Yoder, the next major accommodation case, and Sherbert were very distant from the kind of mainline Christianity whose traditions had influenced the civil religion regime. So Yoder presented really no threat to the disestablishmentarian dismantling in the court's Establishment Clause doctrine. Thomas versus Review Board mandated accommodation even if, or perhaps especially if, an individual claimant's beliefs ran directly contrary to the beliefs of the religious group, community, or tradition with which the individual claimed association. And so exemption in toto here supported a vision of religion and its place in the American polity, subversive of the American civil religion regime of the 20th century. Exemption reflected the view that religion is individuated, private, balkanized, idiosyncratic, and socially splintering rather than unifying. It was no longer in a kind of position of mutual support with the state, but instead in opposition to the state and in a kind of position of perpetual supplication. The same is true, I argue, for the era of RLUIPA and the rise of prison religion. So the elevation in the federal law of religious accommodation of prison religion was important because that special legal status expressed something distinctive about the polity's view of religion's true nature and function. And religion on this view is supported and promoted in accommodation laws like RLUIPA as something like the opposite of the civil religion that preceded it. Now, at this point, I should emphasize, I am not expressing a view about the wisdom of religious accommodations, whether in prison or anywhere else. I'm trying to make an analytical point about the political dynamics of establishment and free exercise. Okay, now, maybe things have changed. Most of our fights today primarily concern free exercise, not establishment. If you look at Hobby Lobby or Little Sisters of the Poor, Masterpiece Cake Shop, Espinoza, Fulton, and on, free exercise seems to be all the rage in all senses of rage. Not to speak of the COVID cases, which are certainly rage-inducing. So yes, there are some Establishment Clause cases about dilapidated old crosses and so on, but they seem to attract much less attention and controversy. Does this mean that free exercise or accommodation specifically has today taken political priority to establishment? I don't think so. And here I consider the claim, I think, raised principally by conservatives and libertarians, that the rise of the regulatory state is responsible for the growth in political importance of religious accommodation. And on this view, with a kind of hat tip to Tocqueville, private rights of association and exemption are ways to resist the administrative state, to kind of curb it. But I say that explanation really doesn't work, and it may obscure more than it illuminates. Number one, the timing is off. Accommodation for regulatory resistance purposes is a kind of 21st century strategy. The administrative state is at least a century old, at least. So what happened in between these periods? Number two, many of these groups benefited by regulation. So regulation is what made it possible for them to exercise what they saw as their religious freedom. And third, and I think most importantly for my purposes, the view that religion and regulation are inherently at odds contains a flawed assumption that civil religion and real or authentic religion are severable. Now, it is true they may not be identical. Political concern with the transcendent is not knowledge of the transcendent. But if we want to explain accommodation's ascent as a political matter, we have to factor in political or civil religion. And once we do that, we can see why these groups are seeking accommodation. These groups hold to an older view of the public expression of Christianity in their public-facing work. And so what changed wasn't the administrative state itself. What changed was that the conception of civil religion that had made the public religious exercise of these groups possible was repudiated. At the end of the piece speculates about the successor civil religion regime, what that might look like, what features of the Constitution will have political priority. We could certainly talk about that, though I really don't have fixed views on that matter. What would be especially helpful to me is some views on possible payoffs or implications of this analysis. Again, I'm not sure that there really are any payoffs, but I'd welcome your views about that. Thank you very much.
Great. Thank you, Mark. Shaakirrah, so 12 minutes, and I will give you cues in the chat about time.
Thank you. Thank you very much. I'd like to thank the conference organizers for inviting me to be here this morning, as well as Professor Murray for agreeing to give comments on my piece. I've so much enjoyed hearing the first 3 papers today, and I look forward to hearing all of the other papers this afternoon. So this is my 3rd piece on the subject of gagging legislation. It's been passed in a minority of states, but in those states where gag legislation has been passed, it's been struck down so far, and there are a number of cases that are pending in federal district and circuit courts around the country. Most of the early gagging legislation, and that which I refer to here, is agriculture based. So it's been referred to as agriculture security legislation, agriculture privacy legislation, or ag-gag laws are a more common moniker for it. So these type of laws do a number of things, and it depends on what state you're in, what the law is trying to do. But here in Idaho, we had a law that prohibited misrepresentations or falsehoods to gain access, to gain employment, to gain entry for purpose at an animal or agriculture facility. So basically a farm or some factory or industry type of situation where animals are being processed for commercial purposes. These laws also kind of had a little moniker in there that if you used these misrepresentations or otherwise gained access, and then you took a recording of something that happened there, now you're guilty of a crime as well. And many states made these either criminal offenses or civil offenses. So you have a broad intent to prohibit the use of misrepresentations to gain access, whether it's for getting records, whether it's for getting employment, whether it's for going in there to take videos. These are civil and criminal offenses. Now, you may be wondering why would many states pass these type of laws? Well, for many of the states, what you saw were disclosures of recordings that were pretty devastating to the business interests of the company. And a lot of that displeasure translated itself to the state houses where many of these businesses are located. And so you can look through the legislative history of many of these type of laws, and it makes very clear that there is an intent to prohibit undercover investigations or really any other type of disclosure of what happens at these businesses. And not many of these legislatures appear to put forth a theory other than it's bad for business that there are these videos that come out. So as I've stated, I've done, this is my 3rd full article on the subject. The first article really looked at how these type of laws affect the workers, particularly undocumented workers who already exist under a fair amount of coercion. The next article was an article that looked at the interest that these laws sought to protect. In particular, when this law was defended in front of the 9th Circuit for Idaho, they put forth the interest, or attempted to put forth the interest, of corporate privacy, and they were reminded by the court that that's not a protectable interest for a business. That article looked at this corporate privacy claim under the framework of content-based, content-neutral, and really just asked whether a corporate privacy interest could be either compelling or important enough, regardless of whether it was content-based or content-neutral. Here, I'm coming to an idea that was raised in one of the earliest ag-gag pieces, but not really discussed very much, and to be quite honest, was part of the original idea for the 2 pieces that I just mentioned. So this is sort of the leftovers of that original scholarship. And it's looking at the Sullivan actual malice rule and whether or not that has some place here. Now, part of the reason why I think this is relevant is because there are pieces of ag-gag laws that have survived muster, particular here in Idaho, the Ninth Circuit, throughout the portions of the ag-gag law that prohibited misrepresentations in general, or that prohibited the non-consensual video recordings, would say, hey, there could be really good reasons, right, to prohibit the use of misrepresentations to gain employment or to gain access to records. And there the court really focused on the false speech analysis rule laid out in the Alvarez plurality, which of course exempted falsehoods for purposes of material gain. The Ninth Circuit saying for Idaho that these, right, that prohibiting misrepresentations for purposes of employment and access to records really goes towards that material gain. But I argue that could not necessarily be true for many people who may use a misrepresentation to gain access. As I said in previous scholarship, many people who are undocumented may often use misrepresentations to gain employment. And these ag-gag laws would technically count against them, even if they have no intent to video record while they're there, or even if they have no intent to otherwise negatively affect the business of that company. And it very well may be that they're just the witness to law breaking at these farms or at these companies and just happen to be able to take video. But in doing so, they are now technically in violation of an ag-gag law that covers that type of behavior. The other reason why I think it may be useful to look at other or expand First Amendment doctrines into ag-gag law is really based on some recent movement in this area. A year ago, you had one state, West Virginia, attempt to pass a gag law that not just applied at animal and agriculture businesses, but at every business in the state of West Virginia. Now, that bill did not pass, but I could very well see states in the future consider these type of universal gag laws that could possibly help you get around the content-based problems that these early animal and agriculture-based ag laws had. Finally, the other reason why I engaged with the Sullivan actual malice rule is Justice Thomas's recent doubt of its viability or usefulness in assert denial dissent in the McKee versus Cosby petition. There he seemed to focus a lot of his dissent on the public-private distinction from Gertz and Dunn and Bradstreet. And I think a lot of that has value, as I talk about every year in First Amendment, especially given the current internet world. It is very difficult to figure out who's thrusting themselves into public matters and who's being thrust into public matters. And to some extent, they're all treated the same. And so further exploration of that area, I think, is quite useful. But this wholesale doubting of Sullivan, I quite honestly found somewhat surprising, given Sullivan's value to the civil rights era and movement in general. And of course, the over 50 years of jurisprudence that we've gotten from this area and the way that it applies beyond just defamation, but also to invasion of privacy, as well as intentional infliction of emotional distress. Now, let me also just say that we see that Sullivan is just useful in a lot of different ways, and I try to show that throughout my pieces in this area, to be quite honest, by the number of cases that we've seen recently on sort of disclosure of private matters, even for public figures like Hulk Hogan, right? He recently won an invasion of privacy claim. I point out in this piece in particular that international case of some interest to some people involving the Duchess of Sussex actually implicates some US privacy law where the judge there even doubted whether she would have some protections in the US. And I point out maybe she could. If she did, the actual malice rule would apply because of course she is a public figure. Here I point out how the actual malice rule could fill in some of the gaps that Alvarez left unfilled in its application to gag laws. I point out that even a universal gag law may need to have some type of actual malice requirement. I also point out how an actual malice requirement could apply to the leftovers of Idaho's ag-gag law, which is still on the books here in our state, has yet to be challenged. And many wonder if it would ever be challenged. But I do suspect that there are some people who are living already in coercive environments who work at animal and agriculture facilities in our state, who are much less reluctant to possibly report violations of the law, given that parts of Idaho's ag-gag laws still exist. So I only have about a minute left, and I do not need to take the rest of it for this talk. I do want to thank you for your interest today. As I stated, this is, or I may not have stated this, but I still think about, what is the value of this original idea? And so the opportunity to present it here today really was exciting to me and gave me a lot of sort of engine for my little choo-choo train to continue to work through these issues. So once again, thank you for the invitation, and I look forward to the rest of today's conference.
Thank you, Shaakirrah. These are great papers. Thank you so much to all of the authors for presenting them. Let me start first with a set of global comments for all of the presenters. All of these papers consider various aspects of First Amendment doctrine and the tension between the commitment to First Amendment protections for religious liberty or speech and other constitutional values like equality and the public's right to certain information. And interestingly, though all of the papers acknowledge the court's recent responsiveness to certain kinds of First Amendment claims, notably free exercise claims, no one actually engages at length with the broader question of what a newly reconstituted court might mean for all of those questions. So one of the things that was sort of lurking in my mind as I read the papers was, how does any of this play out in a court with a 6-3 conservative supermajority in which there seems to be a very robust appetite for a more robust and emboldened understanding of free exercise as opposed to other kinds of First Amendment values? And I wonder if the commentators might think about that and sort of thinking about how to situate these papers as they prepare to submit them, or if they are in the process of editing them, whether it would make sense to not only engage with what's going on vis-a-vis the COVID cases, but also more broadly, the kind of social, political, and I guess legal realism milieu in which the justices are operating right now. So I hope maybe that could come into the discussion at some point. It's also worth noting that there are a lot of ways in which these papers are in conversation with each other. And I think that speaks again to how pressing and urgent some of the questions are that are being raised. And so I hope as the conversation evolves over the course of this session, they'll have some time to talk to each other about the ways in which their papers are actually responding to or maybe in conversation with each other. So let me first turn to Luke's paper, which I thought was really fantastic. And Luke, I've enjoyed your work for many years, so this was really a treat to be able to see where this project is going. And I think one of the questions I had for you was whether you are selling the court as a whole short as an agent in pitting the First Amendment against equal protection. You write in the paper that the interest in prioritizing First Amendment values over equality values really comes from the dissenters in Romer, Windsor, and Obergefell. But I would note that actually Justice Kennedy is probably the one who sets a lot of this in motion. Certainly in his oral argument comments in Romer, and then again in his actual writing in Obergefell, where he actually lays out the prospect of religious accommodations from objections to same-sex marriage. And similarly in Bostock, Justice Gorsuch, despite his reading of Title VII, seems to also read into RFRA a more robust understanding of the statute. He calls it a super statute. So again, I don't know that it's just the dissenters here who are emboldening this understanding of free exercise. I think it happens on both sides of the court, and certainly even for those who have written opinions that might sound in the register of a more progressive view of LGBTQ equality. I would be interested in the paper in hearing a little bit more about the contrast between the libertarian view of the First Amendment that you've identified with the kind of masking function that civil rights statutes are believed to provide. So, for example, when the Civil Rights Act was first passed, it was defended on the ground that requiring compliance with civil rights norms not only widened access for groups that historically had been dispossessed, but that they also ensured that those among the majority who actually did want to expand their businesses to include African Americans and other minorities would not be singled out by their neighbors who disfavored such inclusion. So basically, the idea is that requiring compliance with the law masked intent, shielding those who favored a broader understanding of civil rights from claims that they were race traitors or worse within their very small community. So I wonder if that would not scaffold or help bolster your claim of an anti-subordination First Amendment, just sort of thinking about the way in which these civil rights laws were meant to bolster the civil liberties, the First Amendment liberties of these white objectors in the South who actually did want to make their businesses available to a wider range of individuals. So that might be one place to think about. It's also notable that the paper focuses primarily on free speech as opposed to any other kind of First Amendment value. But much has been written about the way in which the objections to same-sex marriage and LGBTQIA equality more generally are undergirded by religious belief in many cases. So I wonder if it might not be worthwhile for you to also consider, alongside the free speech considerations, whether the court's robust defense of free exercise has something to do with what we are seeing. And then finally, I wonder about the unintended consequences of your defense of an anti-subordination view of the First Amendment. And to my mind, thinking about anti-subordination in the way that you have may also, I think, unintentionally bolster views like those of Justice Thomas, who argue that race-conscious measures have unappreciated stigmatic consequences that in turn subordinate minorities, even though they are meant to help minorities. So again, maybe something to think about, or at least to advert to in the paper. For Stephanie and Justin, I thought this paper was really fantastic, obviously very much informed by Jamal Green's work, which I think is fantastic. And I learned a lot from the comparative perspective that you offer. I was focused though on the discussion of the cases and the different sort of determinative factors that you had laid out, whether the court is required to treat religious claimants the same as similarly situated secular actors, and that might explain their outcomes, or whether the court has placed the burden on the government to establish necessity, and that explains the outcome, or finally, whether the court yields to the temptation to redefine the theological stakes in ways that would minimize the consequences to religion. I wonder if there's not a fourth determinative factor that is also in play here, and that might be thinking about whether the religious claim in question is one that is brought by a religious group that might be understood to be a kind of majoritarian religious group, a mainline religious group, or a religious group that is seen as more minoritarian or fringe. So I'm reminded of Jeremy Kessler's work on First Amendment Lochnerism, and specifically his discussion of the Jehovah's Witnesses cases from the 1940s moving into the 1950s. And you reference both Gobitis and Reynolds here, and I think part of the reason what could explain both Gobitis and Reynolds is the fact that these are not mainline religious groups. They're actually religious groups that are not only fringe to some degree, but also deeply threatening to the understanding of the project of democracy. The witnesses are not just against the war, they are militantly against the war in the 1940s. And Frank Murphy notes this in his Dissent from Prince versus Massachusetts. In Reynolds, you have the Mormons in Utah not only being viewed as antithetical to the basic tenets of democracy, but perhaps being race traitors as well. And Martha Ertman's work has really laid that out. So, I wonder if that's part of what's going on here and how that would fit into these three schemas that you've identified. And then finally, I wonder how you would characterize a case like Trinity Lutheran versus Comer or Montana versus Espinosa in this particular dialectic. I imagine that they would fall into your second category, where the government has failed to establish the necessity of excluding religion. But then again, I also wonder if this doesn't raise the point that I've made about a fourth category, that the more expansive understanding of free exercise that we see in these cases also reflects the degree to which the religious claimants are part of a mainline religious project. For Marc, I really love this paper, Marc. I think it's a really important intervention. And so some of my observations are really about how you frame the paper for consumption by a broader audience. I think here it is worthwhile to note that what you are doing with this paper is intervening into a conversation among church-state scholars that in recent years has really focused on the idea that there has been a diminution in the importance of the Establishment Clause and an emboldening of the Free Exercise Clause by contrast. And I think if you sort of set that out in the outset, what follows is actually an incredibly helpful primer on how to think about the prioritization of one versus the other, and whether that prioritization actually makes sense. I will note, I don't write about the First Amendment on a regular basis, but there was a paper that Alice Ristroff and I wrote in 2010 called Disestablishing the Family, where we applied a First Amendment lens to the question of the constitutionality of particular family forms, and indeed what we call the establishment of the marital family as the preferred family form. And we had a discussion of Yoder, not Sherbert, but Yoder specifically in that paper, where we talked about cases like Reynolds as reflecting a kind of thick establishment of the traditional marital family in contrast to the polygamous family. But Yoder was sort of interesting because it's almost exactly the same case as Reynolds, except that the Amish aren't viewed as threatening to the project of democracy as the Mormons were in the 1890s. And indeed, when Yoder is decided, the way the court talks about the Amish is very consistent with a kind of American ethos. And so there's a way in which Yoder and Sherbert reflect a kind of tolerable pluralism about the prospect of different kinds of religious expression and religious sects. And I think that's something that you could make more of in the paper, certainly in talking about Sherbert's role as emblematic of this dismantling of the civil religion regime. I think Yoder and also the court's treatment of Reynolds reflects both the establishment project and then later the dismantling of it. It may also be worthwhile to note the racial dynamics of Sherbert as well. Seventh-day Adventists are generally Black, and Burt Newborn makes this point in his article, The Gravitational Pull of Race on the Warren Court. Although it is nominally a First Amendment case and free exercise case, there's also a civil rights aspect of it that doesn't come out in the court's opinion, but is certainly known to the lawyers at the ACLU who are litigating the case at the time and advising on the case. And again, I come back to Trinity Lutheran and Espinosa, and I'd love to hear more about what you think about these two cases as perhaps leaning toward reassembling the civil religion regime that you say has been dismantled with Sherbert. And then finally, the administrative state as a factor. I think it's worth noting here that the administrative state is under siege from this particular court. And I wonder how that plays into the kind of religion and free exercise interest that we've seen as well. So another bit of grist for your mill. And then finally, Shaakirrah, I think I learned more about agricultural privacy than I ever thought I would learn in this case. Thank you so much for this. You've really mined this entire vein in your work, and you've done a really amazing job with it. I wonder though, if this paper isn't bigger than the agricultural privacy laws that you've focused on. And I wonder if you might think about other places where you could also talk about a kind of corporatist turn in the court's First Amendment jurisprudence and call attention to that using the agricultural privacy laws as an example, but not the only example. It occurs to me, and again, it's not my field, but there seem to be a lot of places where you could find similar impulses. Citizens United, certainly, lots of different places where I think the same kind of impulse can be glimpsed beyond agricultural privacy. And I think that would make this paper not only bigger, but would also showcase all of the tremendous work that you've done on agricultural privacy in the past, but shows that you have even more range in thinking about these questions and a broader eye in understanding how these same dynamics play out in other places. I think there's a lot going on right now vis-a-vis some of the different kinds of legal doctrines that you've identified here. And I think it would be really important to broaden your discussion beyond agricultural privacy to think about the defamation cases that have been raised in just the last couple of months in the context of the election. So I'm thinking specifically about the owners of various voter system companies who are challenging and litigating against the Trump administration on defamation claims. And these defamation claims will turn on the whole question of whether the voting system company is public or private for purposes of the defamation claim. And so that might be, I think, a place where you can get some more traction and also frame the paper in a way that will be really relevant and timely for student editors who are looking at these papers in the next cycle or the cycle beyond that. And then finally, this also relates to something I said to Mark. I think Burt Newborn's paper on the gravitational pull of race on the Warren Court would also be very useful to you here, especially in your discussion of Sullivan. Burt does a really extensive treatment of the way in which Sullivan is nominally a First Amendment case for the court, but is understood by everyone who is working on it and the members of the court themselves as actually a race and civil rights case. And he has a really fantastic discussion of it. I think the paper is in the Supreme Court review. I want to say it's either 2000 or 2010, something with a 0 at the end and a 2 at the beginning. But I think sort of thinking about all of that would be very interesting, especially given the way in which you've linked these agricultural privacy laws to the mistreatment of workers, and particularly workers of color. Right, so I will stop there. We have lots of fantastic audience members with great expertise in this area. And so I will keep the queue. Please just raise your hand. You can find the hand raising function in the reactions, and I will just keep the queue as we go along. And Mark, terrific.
I'm getting better at learning. Unmute, stop video. One thought, this goes on something Professor Murray said about the contemporary court, is as I read Masterpiece, as I read a great many decisions, I first come to the conclusion, if I only read Supreme Court decisions, it's very clear Sam Alito is the most vulnerable person in the United States and a member of vulnerable minorities. But how do some of these theses play out in a world in which the vast majority of white Christians, particularly white evangelical Christians, believe in fact they are members of the most vulnerable minority in the United States, and they clearly are supported by at least 3, if not 5, Supreme Court justices?
Does anyone want to take that or respond to it? Or just sit with it?
Was that question for Luke?
It was some for Luke, but for anybody, I think it can, in other words, and Melissa asked, how would this play out with Justice Thomas? I was suggesting that in some ways, Neil Gorsuch's opinion in Masterpiece, in fact, plays an anti-subordination theme, only with the wrong group.
I think.
Want to respond, or Luke and Stephanie?
I'll just I'll just jump in quickly and say, you're right. And to speak to Melissa's point earlier, part of the tragedy, personal tragedy for me in writing this piece was writing it in the context of the election, in the context of Ruth Bader Ginsburg passing, kind of not being able to foresee where everything would end up. And so I do think that the current reality of the Supreme Court makes, kind of, from my perspective, an anti-subordination approach to both equal protection and free speech less likely, at least in the immediate term. And so for me, it's more of an aspirational project. Because we've seen anti-subordination emerge in previous eras, because we've seen the court, even in the free speech context, be concerned about the way in which speech can distort the marketplace of ideas when the powerful have too much power to speak. I think I'm pushing for a revision of doctrine at some point. And part of the problem, I think, is how did we get here? And I think how we got here is part of the point that you were making, which is that the free speech clause and the kind of speaker neutrality and content neutrality rules have really been weaponized, I think, to a big extent by folks on the right who now claim that they are truly vulnerable minorities who are being discriminated against by the elite or whoever it might be. And I think that rhetoric and that framing is part of why both the Equal Protection Clause and the Free Speech Clause have moved in the direction that they've moved. And so this is, for me, kind of a project of reclaiming doctrine. But Stephanie, I didn't know if you wanted to jump into.
No, I had a question to add on to that, but so that great response, Luke. I can just be in the normal queue. Melissa, I didn't mean to hop the queue, sorry.
No, feel free, go ahead.
So one question that I think is related to the excellent question Mark was asking is, in addition to how do we define which classes are going to, I think, be entitled to more of those protections under those equality norms and trying to remove some of those structural historic barriers that exist. I'm just curious, and if you touched on this, Luke, I apologize. I'm interested if others have thoughts about this too, but what do we do if you have both of those classes on the side of a free speech dispute? Does that mean that then that consideration in favor of equality goes away? Or would you look at like which of those classes had historically faced more obstacles? And maybe that's a project for a different time, but I found myself curious about how that would work out.
I don't want to hog too much time, but I can just briefly respond. In the Harper decision from the Ninth Circuit that I talk about a little bit, Judge Kaczynski raises the same question in his partial dissent, and he kind of points to a religious minority kind of up against the LGBT person, and there's this speech conflict, and he said, well, how do we reconcile the two? And I think that the response also speaks to one of Professor Murray's concerns about what are the unintended consequences of this anti-subordination approach, which is, do you open the door to sort of flipping the concept of subordination on its head? And I think that the reality is that it's always going to be very contextual. I think in the context of a religious minority against kind of a racial minority or a member of the LGBT community, I think there's a difference between an isolated religious belief and an attack on that person as someone from a particular religious group. And so I think it really depends on what work the speech is doing, what exactly this speech is about, and what the context is. And that does kind of pose a risk, which is that you insert kind of more potentially subjective judicial decision-making into these kinds of claims, where you have to balance these competing, not very precisely defined contours.
May I say one thing?
Sure, Mark.
Great, it is very fast. And I think responds both to Melissa's initial question, the global question, and to Professor Graber, and that is one thing I don't have in my paper, and it's kind of at the end, is the sort of implications or payoff point, and because I don't know that really there are any, but to the extent that there are with respect to the question that Melissa and Mark are asking, it perhaps might be to diffuse things a little bit when it comes to accommodation, that accommodation cannot serve, if I'm right, it cannot serve as a real tool of culture war resistance, because it's not designed to do that. In fact, quite the opposite. It's designed to reinforce certain things with respect to what really matters, which is the regime. And so if people were to listen to me, they might realize this structural political feature of accommodation, and we could take the culture war elsewhere, right? We could focus on other things than accommodation if I'm right about that. So maybe that's a kind of a semi practical implication of what I've got in mind.
All right, terrific. So Marty, you're up, and if you have questions, please just raise your hand or chat to me directly.
Sure, thank you. Thanks to all the panelists for awesome presentations. It's terrific. I may be, my question really is for you, Luke, and I may be sort of channeling Stephanie here. She may have sort of already touched on this, but I too am a little focused on the question of unintended consequences in your paper. And I think I might, I think the way I would diverge from the way that Stephanie asked the question is, what are the dangers here of sort of a strategy that has been used increasingly effectively in the race area, of essentially any time you're sort of trying to privilege certain groups' rights based on history, based on past discrimination, you sort of leave the field open a little bit for folks to play one group against others. I'm thinking here, for example, of the Harvard affirmative action litigation. I don't know if that concerns you. I don't know if that is a consequence that I don't think it derails your point at all. I just am kind of curious about whether you've thought about this as a strategic matter as well as a matter of norms.
Just quickly, I'll say that the possibility of balkanization and kind of intergroup conflict and resentment does concern me. My response, I guess, is that it doesn't concern me enough to advocate for the more libertarian or formal equality approach to either free speech or equal protection, because I agree with, so Professor Erwin Chemerinsky has a really good book called, The Case Against the Supreme Court, where he says one of the court's key function is to protect the rights of vulnerable minorities, kind of regardless of how unpopular that might be. And so I think that just as an inherent concept of what our Constitution is supposed to do, there will always be these conflicts. There will always be groups pitted against one another. And so I think that this is a reality that I have come to accept.
Thanks.
Anyone else from the audience? I have other questions too. Oh, okay, Robert, great. Robert, you're muted.
Hi, Robert Goldstein at UCLA. I think it's important to distinguish the anti-stigma or anti-meaning from the anti-subordination claim. Brown brought the two together effectively, but for anti-subordination, I really take Michael Walzer's Spheres of Justice as the sort of finest description of it. And that means that there has to be a ramification across spheres of social life. It can't just be in one sphere in order to make an anti-subordination claim. And that was clear in the range of rules involving African Americans and segregation. But as the regime changes, and you don't have that violation of spheres, you don't have the ramification across spheres, the claim of being able to make an anti-subordination argument it reduces. Stigma claims remain as part of a prior regime of subordination, but at some point they have to be separated, or the argument has to be how the stigmatic, the words that wound claims really serve to reinforce and maintain the subordinated position. But I just think it's very important to keep having to make those empirical claims about how stigmatic or permitting stigmatic statements will actually have a subordinating impact, and that those have to be empirical claims. And will be different for discriminations that were that led to segregation rather than closeting. Those are, you have to make different kinds of empirical claims about it. And so the empirical claims that you might make in a school will be very different from the empirical claims you have to make elsewhere. And I just think it's important in developing an anti-subordination argument, not just to invoke the idea, but to actually show how stigmatic communication will reinforce and maintain the kind of subordination that Brown was talking about, or that Lawrence was talking about. And you can't just keep you can't invoke the idea without making the empirical claims, because anyway.
Sorry, we have about 9 minutes left. I want to make sure everyone has a chance.
Yeah, I'm sorry.
I apologize for interrupting you.
No, absolutely. I went on too long.
Luke, do you have a response?
Just quickly, yeah, I don't disagree. I do think that the stigma-based kinds of claims seep in to the subordination concerns that I have, but in all respects, I would hope and anticipate that these kinds of claims would be fact-specific and empirically based, and that's exactly what the Ninth Circuit did in Harper, was focused on empirical interdisciplinary research to talk about the way that the stigmatizing speech created both tangible and intangible harms, but importantly, the tangible too. So just a quick response.
So a question for Stephanie and Justin, and possibly even Mark as well. The comparators that you use from other jurisdictions, I mean, how much of the difference can you attribute to the fact that those particular populations are largely racially homogenous in a way that the United States is not? I mean, there's a way in which the United States experience with the First Amendment is sort of undergirded by the real fact of pluralism, not just religious pluralism, but other forms of pluralism in the United States that is just not present in other countries. Maybe Canada is a perfect comparator, but some of the other countries in your study may not be. And again, Mark, I think some of the points that you make in your paper sort of gesture toward this idea that part of the US disassembling of the establishment project is about this underlying interest in a more pluralistic democracy.
Quick response. I think some of the cases we look at are driven by anxiety about the disappearance of the homogeneity that you're talking about, and so we'll see where that development goes. And I think some courts seem a little bit more comfortable with increasing pluralism, and some more deferential to the government's anxieties about it. We didn't write a lot in the paper about South Africa, but that's a pluralist society that uses proportionality in ways that don't strike me as dramatically different from what we saw in the other jurisdictions. But that's a great question.
Yeah, and just to add to that, and thank you for the question, Melissa. The burqa bans that we see in other countries, I think, are consistent with what Justin's talking about like in some ways a desire to keep homogeneity in ways that are really problematic and to marginalize groups like Muslim women. And so I think that's an example where one thing we talk about in the convergence section of our paper is maybe not every government interest should always count as something that can be weighed in favor of the government, because there the interest the government relies on is the idea of getting along together in society, which that sounds like a euphemism that can be used against vulnerable and less popular groups in a troubling way. And So yeah, I think that's one reason why when you're balancing government infringement on religion, maybe sometimes not every justification should be a good one for that.
Mark.
So I'll just have two quick things, Melissa, on your excellent question. First, I think it's undoubtedly the case that pluralism was something that the court was responding to in one way or another in its disestablishmentarian doctrine of the mid-century. And so one of the things I have to be careful about is, there were these other social and cultural forces going on, and those are the ones that are almost certainly, not probably, certainly the primary driver of the doctrinal and legal changes. Although I think there's a kind of mutual action and reaction. That's number one. Number two, I think it probably is an implication of my paper that even though that's true, pluralism will never be bedrock. That is to say that that just the sort of fact of pluralism is not, in my own view at least, one of what I call the civil religion regime settlements of whatever it is that will come. Something else will define them, and I sort of gesture toward, at least in law, other constitutional doctrines, other rules of anti-discrimination as being the settlement, as establishing the regime, not pluralism itself. So I guess I can explain that further, but I don't want to take up more time.
No, it's a great point. And I don't mean to say that pluralism explains everything. I mean, as I say, with the reference to the paper that Alice and I wrote, it is a sort of tolerable pluralism as opposed to a real interest in a more robust kind of pluralism. If there are other questions from the audience, I'm happy to take them, or I have questions as well for Shaakirrah. So no hands. Okay, Shaakirrah, I'm going to go for it then. You make a lot of Justice Thomas's words in response to Sullivan here. Should we really worry about it? I mean, I'm not sure. I don't even remember if he gets another person to sign on to this opinion. I don't think that he does. But is there a worry that he is otherwise influential in this way, and that he's sort of gesturing towards something that will later come to pass?
So we've only got 3 minutes, so I'll make it quick. And thank you for not allowing me to sit here and chill for the rest of the afternoon. So I'll just say first, I'm not trying to start a beef with Thomas, to be honest. I got an early critique on this, and that is how it was brought to my attention that he had something to say. So for me, it was just a thematic thing, also because I focused on his Reed decision in the prior article on ag privacy. And really that one is about corporate privacy. I kind of wanted to have that continuity. And I think I was, trying to struggle, like, what's my theme here, right? I really also do think, I don't know. As I tell my students, me and Thomas are frenemies, as me and most of the justices are, past, present, and probably future. And I have felt, I'll be honest, to the extent that he's the only African-American on the court. And I'll say, I think he was the presiding judge of the 8th Circuit, which is where I clerked. I think I just have some imaginary metaphysical connection to him that I've just wanted to kind of play off of, I guess, a little bit and engage. And so I do try to sort of bring out other points. I'll just say, it also is curious to me that this is the case that he chooses to speak out on, given the subject matter of the Cosby issue. I guess, maybe I was trying to start a little something, but not really, because, but it does not escape me that his voice on that particular subject is notable. But not too many other people have noticed it. So I guess I just wanted to sort of find that little space.
So just, again, this may help with the paper. A lot of people have done work on Justice Thomas as a justice and what he's bringing to the table. So there's Angela Onwuachi-Willig's work. You may also find Guy Charles's work on the Virginia versus Black case, the cross-burning case. I think it's in the Georgetown Law Review, and he speaks about the epistemic authority of Justice Thomas and weighing in on questions of race. And you may find that useful as well, Luke, because I often thought about Virginia versus Black as I was reading your paper. And additionally, Shaakirrah, I worry that the real strength of Justice Thomas's intervention here is not necessarily with regard to whether he has persuaded his colleagues to follow him, but rather if he has sort of seeded a whole cadre of former clerks who are now federal judges and cultivated this kind of interest. And so it might be worthwhile for your project to think about or look for how some of these ideas are percolating in the lower federal courts as well. Right, so we are exactly at 10 o'clock. This has been terrific. Thank you so much to Luke and Stephanie and Justin and Shaakirrah and Marc for these great presentations. And thank you so much to the audience for getting up early on the West Coast for this, or staying up on the East Coast, if you will. This has been a really fantastic session. Thank you. And thank you to the organizers of the conference.